Today's lecture we'll be looking at the American court system. Much like the policing system, it's based on the English tradition, where we get a lot of our governmental systems from. So we're going to take a look at some of the specific aspects of it today. Much like the policing system, there's a dual system of the courts, federal system, and then local, state, whatever you want to call it, the federal system, and then everything else at the state, local, city level. But just the two main groups are the federal courts and then the local courts. Jurisdiction is an important thing to note in the court systems. Jurisdiction basically means who has the authority to hear a case. Sometimes that's based on where the crime took place, what the nature of the crime was. Is it an actual crime that we're dealing with? Is it a civil suit? Is it an appeal? Sometimes, though, there are overlapping jurisdictions, you have concurrent jurisdictions, where more than one court has the authority to hear a case, and in that circumstance, they have to sort of work it out. They have to figure out if it's is the federal system going to handle it? Is the state court going to handle it? Is the county going to handle it? And then that's just very situation specific as to what happens in that circumstance. The federal court, we'll look at first. For the most part, the cases heard in the federal system are civil cases, cases by parties where they're trying to seek some sort of remedy, whether that's money or preventing something from happening. A recent civil case dealt with the release of John Bolton's book. The elements in the government and the White House tried to sue to have the book not released. The court heard the case and is allowing the book to come out. I think Amazon said mine's supposed to be here on Thursday. We'll see what happens. But the vast majority of cases heard in federal court are civil cases, so not criminal trials, settling disputes between parties. Those cases are heard originally at the district courts. That's where you're going to have the majority of the cases come in, both civil and criminal. Like I said, the vast majority of cases heard by these courts are civil cases. Think of the district courts, we'll call them trial courts, where the trials take place, is what they would show in TV or movie. This is, the sort of daily operations of the court. The next level is the appeals court, which is the federal system is broken up into various geographical locations. On maps in the textbooks, we'll look at the federal appeals court maps, try to find where Georgia is, where Atlanta is. Those they do exactly what they say. They hear appeals from the district courts, also from if a case goes all the way through a state level court, then they can make an appeal to the federal appeals court. Above that is the Supreme Court, and it's basically just another appeals court. It's important to note the Supreme Court doesn't have to hear all the cases that are brought to them. They typically only hear usually less than 5% of the cases that are actually brought there. What has to happen is 4 of the 9 justices have to agree to hear a case, and then it goes on the docket. They don't have to say one way or the other. They just have to agree there's enough merit in the case for them to make a decision. In the state systems, it's basically 50 different systems. Each state has their own little specificities. I'm going to talk generally about these, but a lot of what I'm going off of is the Georgia system. So it's important to note if you want to look at specific court systems for a particular state, you need to look into that. If there's any sort of trying to get a job somewhere, or you have to deal with the court system in some way, it makes it's very important to educate yourself about the system that you're going to be operating in. But overall, it looks fairly similar to the federal system. You have those trial courts. Some local level courts are what are called courts of limited jurisdiction, and they're only going to hear specific minor offenses. So in Atlanta, we have a municipal court. They hear very minor offenses. And then we have the city court, county, state, all of those could hear trials, can hear complaints, criminal and civil, depending on what the case is, depending on what the court is. But those are all the trial courts. Then here in Georgia, we have two sets of appeals courts. We have an appeals court. Again, same thing that the federal system does, offers a chance to review a case. Then we also have the court of last resort, which is Georgia Supreme Court. Again, works the same way as the, well, not necessarily the same way as the federal Supreme Court. They have their own specific laws. For instance, in Georgia, anytime someone is sentenced to the death penalty, the case is automatically heard by the Georgia Supreme Court. They review the cases that are brought to them. Some of them they have to review. Some of them they make the decision not to review. But again, based on that outcome, that would lead someone to go into the federal system. Now, there's typically two sides in any court case, so depending on which side doesn't like the ruling, either side can apply to appeal a ruling at a higher level. And so that's what can make court cases take a long time before eventually they either go to the Supreme Court or they're denied by the Supreme Court, which makes the lower court ruling stand. But there's two sides in a case, and a lot of times people are, usually one side's going to be unhappy at the end of a trial. So now we're talking about the courtroom work group. Again, there's some links in the to-do list for videos to watch about the courtroom work group. So I don't think those are embedded in here, but just try to watch the videos as you're going through the PowerPoint and reading about the judges, specifically elected judges, prosecutors, and defense attorneys. Because there's some important things highlighted in those videos about the different actors in the courtroom work group. So basically, we're talking about the people that have to work together on a daily basis. And oftentimes, the prosecution and the defense are working against one another, but they still have to have the ability to work in conjunction with one another on a daily basis on the next case. They can't let things get too contentious to prevent them from being able to do their jobs tomorrow. So the judge takes on three roles in a courtroom proceeding, or in their job. Part of that is in the courtroom, part of that is outside of the courtroom. In the courtroom, they play the adjudicator, deciding on motions and rulings throughout the trial. Sometimes they even act as the jury in the case of a bench trial. We'll talk about that later. Next is the negotiator, sort of working behind the scenes with the meetings of the two parties, the prosecution and the defense, to talk about the rules of the case. If there's a possibility for a plea or a settlement, the judge is sort of like the arbiter in those situations happening outside of the courtroom. Additionally, in areas, so we talked about the police, where they basically do any job that's not done by someone else. In the courthouse, that's the judge. So if it's not done by somebody else, it typically falls on the judge. Jurisdictions with higher budgets can afford to hire legal aides and assistants, secretaries for judges, and things like that. But a lot of the roles and a lot of the jobs in operating a courthouse, especially in smaller areas, fall on judges themselves. So as far as time management, they typically only spend about 3.5 hours a day on the bench. The rest of the time is taken up by the negotiator and administrative roles. So usually less than half the time is on the bench, and some very efficient judges can clear a calendar quicker than that. They do have evolving roles throughout the course of a trial. Sometimes they'll hear the trial. They might also hear the appeal. So they're looking at different aspects, taking different roles and responsibilities of what they're supposed to do during of the entire course of a case moving through the court system. At a trial where there's a jury, the judge is going to have a different role in evaluating evidence, what should come in, what shouldn't come in. They're not the ones that are establishing guilt at that point. But then if they're hearing the appeal of that case, they might be might have a more active role in determining the outcome, as opposed to the jury having that during the actual trial process. So I asked this question in my face-to-face classes, and I want to take the same exercise here. So, who are judges? Think of a judge. Get a picture of a judge in your mind. When we look at the statistics, talking about demographics of judges, more often than not, they are old white males. Okay, so I don't know if that's the image you had in your mind when you hear the word judge, but it's a common portrayal in film and on TV, and that's what we see in a lot of circumstances. There was one place where that was not the case in 2018 in Houston. Texas has an interesting facet of their election system that they've actually gone away from, where when you bring up your ballot to vote, you can just select Democrat or Republican, and then the vote will automatically go to each person on the ticket who's of that political affiliation. So because of this, in Houston, in 2018, they elected the first all African American female bench for the city because of the turnout for the Democratic Party in Texas in that mostly due to the statewide Senate race, but because of that, they had a complete switch in their judges, and also in what we have seen and what we expect to be who a judge is, which is a very positive thing. Judges, much like police forces, prosecutors, should all represent the community that they serve. It shouldn't just be this authority figure maintaining a status quo. The next group of individuals or individual in the courtroom worker is the prosecutor. And prosecutors have the most discretion throughout the court process. They decide to instigate the process at any time. They can pretty much pull the charges back and not have it happen. So they're very, very powerful. And as you see in the video clip, it's very absolute power, really. There's not a whole lot of checks on prosecutors' discretion in these cases. So they're supposed to seek prosecution when they think they know who did the crime, when the punishment is not going to be disproportional to the crime that was committed, and also when the prosecution serves the interest of justice. So what that means is that if justice is not being served by bringing a case to trial, they shouldn't do that. If the reason why the person committed the crime is part of what was happening. For instance, a lot of the people charged in these riots, protests, probably have the charges dropped because the communities don't want to see the continued sort of ripping open of the scab. But in some places they won't. In some places they have a different opinion about the effectiveness and the manner in which these things sort of should happen in their minds. And the charge will probably be sustained, and even very hefty charges brought. It sort of just depends on what the will of the community is. Unfortunately, it also depends a lot on is the prosecutor running for election. Prosecutors are elected officials, and oftentimes that can cloud their judgment, as it has been shown to cloud a lot of judgment of elected officials in recent times, maybe say the last 2,000 or 3,000 years. But again, pay attention to some of the characteristics listed in the text pointed out here when you watch that clip about prosecution. The next individual is the defense attorney, and the right to a defense is promised by the Sixth Amendment. Their duty is to protect the rights of their client. They're not supposed to judge them for being guilty or innocent. They are supposed to maintain their rights and make sure that the state does their job in bringing charges in a proper manner. They're not supposed to lie. They're not supposed to put people on the stand they know are going to lie. They're not supposed to commit criminal acts with their clients or furthering criminal organizations or criminal activities. But they are supposed to have as their first um, charge is to protect the best interests of their clients. And sometimes that means doing things that people see as wrong, as protecting someone that they might see as bad or evil. But the the rights that we have in terms of a criminal defense are only as strong as we afford the lowest among us. So the person that is the most guilty, maintaining their rights is important because that's the standard. That's whatever the lowest standard is. That's what we're all held to. A big issue with defense attorneys is public defenders and how people have access to them, the sort of how overworked they are, and you can see some of that in the clips. For the most part, if a jurisdiction has a need for a public defender's office, they'll have one. They're typically underfunded and overworked. There are some other types of ways that people get public counsel. Some jurisdictions don't have a need for public defender's office, will contract the work out to various local law firms. Some will just do it on a case-by-case basis and pay attorneys to take those cases. Sometimes it's required. So if you want to practice law in this county, we don't have the money to pay for a public defender's office, you're going to have to take some of the cases. It's sort of whatever the need of the local area is. That's what the system oftentimes will conform to. Juries are another very important aspect of the system, basically deciding at the beginning, the grand jury decides whether or not to bring the charges, and then the trial jury or the petty jury decides guilt or innocence. Again, the right to a jury is granted by the Sixth Amendment. As I just said, trial juries are often called petty juries. That's the counter to the grand jury. Remember the functions of the grand jury that we saw in the first PowerPoint and then in the text as well. Depending on what the charge is, depending on what state the individual is in, a trial jury might be 12 or 6 individuals. It might have to be completely unanimous, or it might have to be a majority, 75%, and 9 out of 12 in the case of 12. It just depends on what state you're in, and what crimes you're being charged with. Juries are there to weigh matters of fact within the what's presented to them. So they're there to decide what happened. Typically, anyone can serve on a jury as long as you can read, write, understand, and speak English. That's the language that the trials are most commonly held in. So that is a typical requirement. People that cannot hear or see might be able to be on a jury with accommodations. Most times people don't want to be on a jury. People try to get out of it for various reasons. If you receive jury duty notice and you're in school, you can oftentimes get that deferred if you don't want to do that. And then sometimes they'll send you another jury summons later in the year. It just really depends. Top tip, though, if you want to get out of jury duty and you have to go, you don't want to get picked, tell them you study criminal justice, and they'll more than likely kick you off the jury. They don't want people, they don't want lawyers, they don't want police officers on juries because attorneys feel that those individuals take them over. People that are too knowledgeable of the system, a lot of times either one side or the other will not want them on the jury for a variety of reasons. So the way it happens is people are sent jury summons, and then from those applicants, they pick a 12 to serve, maybe some alternates, depending on what the case is. They do a process what's called voir dire, which basically means to speak the truth, where they ask a variety of questions related to the trial. Some more related than others. Again, if you've watched the prosecutor's video, you've seen how the system can be manipulated in some cases. Particularly through the challenges. And there's two types of challenges for jurors. You have challenges for cause, which are unlimited. If someone, if you're looking at a case involving police brutality or maybe a hate crime statute, and somebody comes in there and they're wearing, a Confederate flag hat, or they're wearing a shirt that's detailing potential left-wing extremist groups, really any type of extremist groups, then you're going to have strikes for cause. The other types of challenges are peremptory challenges, and depending on what jurisdiction you're in, the attorneys have a certain number of them, and they can be used for any reason. You don't typically have to give a reason unless there is a claim of a pattern happening. And again, in the prosecutor video, they talk about some of the issues associated with using peremptory challenges on particular racial, ethnic, cultural lines. So we talked before about how the judge could have a more expanded role in some trial processes. Those are called bench trials. That's basically where the judge is acting as the jury. The reasons that you would do this is if the nature of the crime is very complex, and you don't think a jury is going to be educated enough to understand the nuances of the defense, or if the crimes, especially heinous crimes against children, crimes against vulnerable populations, that people aren't going to be able to look past. Also, particularly hate-related offenses. Judges are supposed to be more even-keeled, having the ability to maintain impartiality better than a jury of your peers would in some situations. Statute of limitations are an aspect of the criminal justice system that's often very misunderstood. The reason we have them is to sort of give the police the ability to clear their books on cases that are particularly old, cold, not having any hope of being solved. But there are some things that are misunderstood about it a lot, and they're sort of changing a lot of these changing a lot of laws around the country to reduce the ability of people to sort of get off on the statute of limitations. So it's important to note that the statute of limitations, which is usually 7 years for felony offenses, first, there's no statute of limitations for murder at all. Also, if you flee the jurisdiction, the statute of limitation freezes. So if you commit a theft in a particular county or state and then flee the jurisdiction, there's no statute of limitations, so it doesn't apply. Also, if you take actions to conceal the crime and try to cover it up, statute of limitations does not apply as well. And also, if there is a continuance of the crime, if it keeps going on, then there's no statute of limitations. So again, it really is something that's becoming less and less applicable in the criminal justice system as we improve our investigative abilities and also going back and re-examining some cases based on modern understandings of different types of offenses. Double jeopardy is another one that's kind of misunderstood. It basically just means that you can't be tried for the same crime, the same aspect of the same crime twice. So if the movie they made called Double Jeopardy, where the lady goes to prison for killing her husband and then gets out, finds out he's alive, and then goes and kills him again, that doesn't fly. Basically means that you can't be tried for the same act at the same crime. So you can't be, for instance, in the Rodney King case, the officers were initially tried for assault, various violent-related crimes at the state level. They were acquitted. Then you go to the federal level, they couldn't charge them with the violent actions. So they charged them with civil rights violations. They charged them with different crimes for the same actions. So you can't be charged for the same crime and the same actions. It's kind of confusing, but basically meaning that the government only gets one bite of the apple. You can't be held in double jeopardy twice. Again, that's assuming that you're not doing something to conceal evidence or supporting perjury, putting people that are going to lie on the stand to try to muddy the waters. But it's more nuanced than just, you can't be, if you go to prison for killing someone and they're alive, really, you can't come out and kill them again. You haven't. You're talking about a crime happening in different jurisdictions, different times, so it's not the same thing. Bail and bond is another important aspect of the system. It's sort of evolving. Again, watch the clip that we're going to have linked on that for bail or bond. The one of the companies featured in that clip, a friend of mine used to work for until he was fired for not wanting to go and work in the virus conditions. We'll see just how bad those incarcerated conditions are next week. I'll show a clip. It actually aired last night, but I'll show it next week when we talk about corrections. Bail and bond are basically just release from jail before a trial. The way that happens is the most common one sort of developing is ROR, or signature bond, where you don't have to pay any money. You just sign some forms saying you're going to come back, and most people come back. It reduces the need for people putting up financial sums of money or property, lets people get out of these facilities quicker, which again, as we'll see in the clip next week, is very, very important right now. So you can do that. You can offer a property bond, which typically has to be 3 times or 2 times the amount of the bond. So if someone has a $100,000 bond or bail set by the court, then they have to put up $200,000 or $300,000 worth of property to be released. Sometimes it's sort of an ROR bond, but they just put conditions on the release: drug, alcohol treatment, maintaining a job, things like that. You can also have a third-party release, which is basically paying a bondsman, which is what you see in the video clip, where you pay them 10 to 15% of the bail amount, and then they guarantee the rest. If you don't show up for court, they will then send a bounty hunter after you, and then you'll have to pay the bounty hunter. It's a pretty predatory system, and that's one of the reasons why they're getting away from putting these high cash bail and bond for individuals, especially poorer individuals, because they can't pay it, and they're basically having to pay money to another company, and they didn't really even do anything in a lot of the cases. If the charges get dropped, you get found not guilty, you don't get your money back from the bail bond. Pretrial motions, that's part of what we talked about in the first lecture, or PowerPoint, are basically there to gain some sort of legal advantage, whether it's change of venue, moving the location of the trial, exclusion of evidence, admission of a affirmative defense. They're basically trying to gain some kind of legal advantage. There's a variety of types of motions. When they happen depends on how the case is going. It's very specific to the case at hand. Okay, sorry about that. I just wanted to see where we're at. Plea bargaining is a very important part of the system. 90% of felony cases result in a plea bargain, and that can be an issue. The main thing is that plea bargaining helps everybody in the system except for the innocent defendant. It's quicker, it's more efficient, it lets the prosecutor, the judge, the defense attorney have more time with other cases. But for the innocent defendant, plea bargaining sucks, basically. You can either plea for a particular amount of time or for the charges. So you could lower the charges and then plead that instance. You could potentially and typically what's going to happen if you are entering a plea, it's a guilty plea, and another sort of, not really another type of guilty plea, but there is the idea of nolo contendere, which is basically accepting the punishment for a crime without having to accept legal guilt. So a plea of nolo cannot be used as evidence in a civil trial, whereas a guilty plea could be used as evidence in a civil trial. So again, basically, it's accepting the punishment without having to accept guilt. Okay. Again, this is just an overview of the criminal trial that we looked at in the first slide. Sorry, the first PowerPoint. So again, just review this. Think about the different roles that the different actors, the judge, the defense attorney, and the prosecutor play in the different steps. And again, make sure to watch those videos. And that the next PowerPoint will be about sentencing and the death penalty.